Well, welcome to the post-lunch session. I know there's another session going on. It's the post-lunch. This is the post-lunch session. This one is called Taken by Storm, and it deals with a special, fascinating area of law and life, dealing with government, you, and property. Most of us know that when government wants to take your property to do something, they're supposed to pay you for it. In fact, the Fifth Amendment of the Constitution requires that they pay you, quote, just compensation. Louisiana's Constitution has a similar provision. It says full compensation. The two terms sound alike, but they're not exactly the same. But over time, the role of government in our lives has changed, both in the kinds of things that government needs property for, bridges, military bases, schools, things like that. It's changed, but so is the role in how they tell you you can use your property. And at some point, if they regulate your property to the point that you can't use it anymore, then it's called a regulatory taking. And according to courts, they have to pay you for it. But what if government action or inaction leads to conditions that deprive you of the use of your property? What happens then? Specifically, what happens if government programs or policies lead to things like flooding, climate change, sea level rise, forest fires, change or even the change to or loss of a water supply? What happens then? It wasn't anything they affirmatively did. It wasn't the object of a regulatory program, but it seems to be a consequence. This is an area that we're seeing some fascinating new developments where we don't know exactly what the outcome's going to be, but all you have to do is look at places like Flint, Michigan to see that, as banks are now telling folks, what you thought was a house that you could use as collateral for a mortgage is a brick and wood monument that we really don't value as collateral, because if you don't have water in it, we can't take it and sell it. These are the kinds of things that are coming up. And this is sort of a glimpse behind the curtain of the panel we have today. And we have three panelists who are as good at this as I can think of, two of whom I shared a panel with in Baltimore in the fall. And then when we decided to kind of replay it, we thought, well, how can we make it even stronger? And it turned out that I left the panel, and we bring in Randy Smith, and I get to moderate. But you're going to hear from three people today with three perspectives on it, which you have to understand them all to get a flavor for not only what are the rights of individuals, but what can we expect of government? What are its rights and obligations and protections? Jim Jett is Principal Deputy Chief, Natural Resources Section of the Environment and Natural Resources Division of the U.S. Department of Justice. In short, he's the government's lawyer when cases like this might be brought against the federal government. Justin Pitto is a professor of law at the University of Denver's Stern College of Law, and he's an alumnus and a former colleague of Jim's. Here in Louisiana, we're very familiar with what happens when floods happen, and sometimes we've seen that when a flood occurs, there might be someone who's responsible for it, not just because they were negligent, because they should have anticipated that they were going to take and occupy your property. Justin, by virtue of living in the West, also gets to see what happens with forest fires. So you start to see that it's fairly complex. And finally, Randy Smith, who is a founder and partner in the New Orleans firm of Smith & Fowler, where he brings some of these actions in addition to a pretty full complement of other kinds of legal representation. But Randy is also the sole Louisiana member of the Owners Council of America. It's a national association of experienced property rights and eminent domain attorneys. to get this kind of talent, you normally have to pay a lot of money. But we at Tulane are making it available to you. You can thank us later. The conversation, I think, is going to be really illuminating, and I look forward to your questions. And we're going to start with Jim. Jim?
Okay, so as Mark said, I am the Principal Deputy Chief of a section within the Department of Justice that does natural resource-related law. It's much broader than the takings issues we'll talk about today, but I wanted to start out by providing the link between the climate change focus of this symposium with our talk and how it relates to takings. In the natural resources section, we see climate change across almost everything we do these days. We do a lot of work in energy policy area, right? So we see the climate change issue in the recent pause that was issued by the Department of Interior on coal leasing, right? And an interesting aspect of that in terms of the climate change issue is, should the cost of leasing coal from the federal government include a component for the social cost of carbon, for example? And so those are sorts of issues we touch on all the time. In the water area, in reclamation and water rights, we see climate change very much in the endangered species component, right? How much of the water in existing waterways should be preserved for the protection of species? And we also see the issue of climate change, for example, in our forest management. What are the appropriate fuel loads given climate change and the impact it will have on forests in the future? How should we manage for invasive species that may be exacerbated by climate change? So we see it across all of the litigation that we handle for all of the various federal agencies. But today we're going to talk about the intersection of climate change and takings. And in that context, I wanted to give you a sense of why it's important that we think about this in the takings context. And I came across a perfect example just yesterday when I was reading a brief we had filed on Wednesday out of our section. And the first line of the facts section of the brief, and it was a takings case that we'll talk about through the course of this afternoon. The first line of the brief, of the facts section was, Northern California was in the midst of a drought due to the driest spring on record prior to the start of the Iron Complex fires on the Shasta Trinity National Forest in June 2008. That sort of opening sentence to our fact sections, the driest, the wettest, is becoming very common among the briefs that we're filing in the litigation that we see. And so we start to think about climate change and the intersection with takings, right? Well, what is the intersection? Well, let's start with things like rising sea level, more active hurricane seasons, and more extreme rain events, right? And what does that lead to? That leads to more flooding, all of those in various ways. You see it when you take the more extreme rain events, you add in more frequent and more extreme droughts, right? And you'll see landslides appearing. I thought after I made this slide, I should have also included subsidence here, right? And then if you take just the extreme and frequent droughts, you'll see forest fires and water shortages. We have seen takings-related litigation in all of these areas so far except landslides. And so don't use this, especially if we have any property owners, lawyers in the audience, as your next entree into suing this, okay? But you can see then that climate change and the impacts of climate change have a very significant potential for impacting takings and how we defend against that. So what am I going to talk about today? Well, I'm going to concentrate on two of those. I'm going to concentrate on flooding and fires. And I'm going to look at what has changed with respect to the jurisprudence in this area of takings when it comes to flooding and fires. And I want to tell you the two things that I've noticed in general are the results have changed and the sentiment has changed. And what do I mean by the results have changed? Well, in the takings context, when it came to disaster-induced takings, flooding cases, and fire cases, the results used to be we routinely had these cases dismissed on motions to dismiss. A perfect example of that is a fire case called the Toon case. This was a case in which the government actually started the fire, right? The government set a controlled burn on federal lands to deal with fuel loading on those lands. The winds whipped up and that fire got out of control and burned onto private property. We went to the court and we said, we didn't cause the taking, the wind caused the taking, and the court on a motion to dismiss said that's absolutely correct. It was Mother Nature that caused this harm, not the federal government. No taking, case dismissed. Now what we are seeing is examples like the Trinco case. This is another fire case recently in which the United States set the fires. But we didn't set it in the same sort of situation. In Trinco, we set it to defend against the onslaught of wildfires that were coming towards a fuel break that we were trying to create, right? So we're in an emergency situation. The classic example of when the government generally gets substantial deference from the courts. And yet in Trinco, we initially succeeded on a motion to dismiss, went up to the Federal Circuit, reversed, and remanded for the government to show that it was actually necessary for the government to take those specific actions in the emergency situation in defense of the oncoming forest fire. What that tells me is, in terms of results, we as lawyers may need to rethink how we approach the defense of these cases. Perhaps the motion to dismiss stage is not the best vehicle for us to pursue the resolution of the cases. Maybe we need to develop more complete factual records to tell the government's story in a more persuasive way with respect to defending that lawsuit. The other thing I want to talk about is the change in sentiment. And here what I mean is that if you look at the jurisprudence in this area, the courts historically, for over 100 years, talked about disaster-induced takings cases, and they referred to the government in terms that made us sound like the savior. The government was coming to save the day. In the most recent litigation, what you see is an analysis of the government's actions that place the blame on the government. You also see this concept developing in the jurisprudence of, in the early cases, Mother Nature causes flooding and fires. In the later cases, you start to see this concept that the government should be able to control Mother Nature, and if it doesn't, it does it at its own peril. So when did this change occur? Well, I think it's probably been a gradual shift over the last 100 years, but one noticeable decision that I'll point out is Arkansas Game and Fish. It's a recent Supreme Court case. Interestingly, I think it has the potential to have significant impact on disaster takings cases, particular flooding cases, even though it's actually not a disaster case, right? This is an instance, Arkansas Game and Fish is an instance in which the United States built a dam, operated the dam without problem for years. For a 7-year period, it adjusted its operation to try to provide more water during the spring growing season to irrigators in the region. As a result, certain forest lands of the state of Arkansas arguably became inundated for longer periods of time during the flooding season, okay? And we ultimately were determined that that was a viable takings claim just because of the shift in the government's actions. The interesting thing is the key issue there was really about how long a duration a taking has to have before it will be recognized by the court. And that really, it's a case that probably shouldn't become controlling in the disaster arena, but I fear it may well have substantial implications. is there a coherent approach that I've been able to tease out between fire and water cases, for example? And the simple answer is actually no, and I think you'll get a flavor for that as we go along here. So there are, however, three themes that I think I've been able to tease out, or at least start to think about in the context of these takings cases. And they're both in a kind of a before and after scenario. You know, the before is the kind of historical jurisprudence. The now is the what's happening today. I would say in the last 10 to 15 years, period. It's a very recent development. The first is the court's focus. It's definitely shifted. The second area is the type of analysis the court is applying. For those who know takings law, the court on a physical taking routinely applies a per se rule. If the government goes in and sets up camp on your property and takes it physically, that's a taking, government, you pay. If it's a regulatory taking, government imposes some restriction on the use of your land, making the land less valuable, then there's a complex test, a multi-factor test known as the Penn Central test, to determine whether a taking has occurred. And what I have been able to deduce is that in the disaster cases, what really seems at first blush should obviously be physical taking. Was there fire on your property? Was there water on your property? Is actually shifting towards a regulatory-like takings. And I say like for a very important reason that I'll point out later. The third thing I've been able to tease out is that at least in the fire cases, the concept of background principles, which is, does the property owner have this right that they complain the government took? Do they actually possess that right in the bundle of sticks that is their property interest? All right? And we'll talk about how that's shifted. So let's start with the court focus. Before, it was on Mother Nature, right? If you look at the cases, you see quotes like, flooding was the result of the hurricane, not the flood walls. It's from a case called Nicholson, which was actually a post-Katrina flooding case. Different from St. Bernard, which is a case I'll talk about in a minute. In St. Bernard, the complaint was that the Mr. Go, the Mississippi River Gulf outlet, was a contributing factor to flooding in St. Bernard Parish in the lower Ninth Ward. In Nicholson, it was simply that the New Orleans levees had failed because they were inadequately constructed. Other language you see are things like fire should be attributed to random events and natural phenomenon. The quote from the brief I just read to you said, the Uinta Flat Fire, not the Forest Service, caused the destruction. I'm sorry, that wasn't from Trinco. That's from Teagarden, which is an interesting case as well. I'll talk a little bit more about that as well. But the language of the cases were all about the severity of the natural event. And because of that, the court said, well, that can't be the government's fault. It doesn't control Mother Nature, right? It did things, like I said, like highlighted the severity of that event. And the result was, not surprisingly then, that the court said, well, there's no liability. Even if the damage is permanent, and even if it can be partially attributed to the government, if the primary contributing factor to the loss of the value of your property was something that was caused by Mother Nature, that shouldn't be visited upon the government. The court focused now, on the other hand, and I'll focus on two cases here, that really seem to ignore the historic nature of the natural event. The first, and the one that you all may know the best, is the St. Bernard Parish case, right? The St. Bernard Parish and residents of the lower Ninth Ward have sued the federal government, claiming that the building and operation of the Mr. Go contributed to the flooding of their properties, not only during Katrina, but during 3 subsequent hurricanes as well. The court wrote a 70-page opinion, and never once in that 70 pages did it ever mention that Hurricane Katrina was one of the most severe hurricanes ever visited upon the continental United States. Never once in 70 pages. The prior case law would have been all over that. The other one is the Trinco case. So Trinco is the fire case, right, where the government set backfires, arguably on private property, to stop the advance of this set of fires that were racing towards it. There again, the court's decision in the Federal Circuit didn't focus on the fact that these were naturally created wildfires. They looked only at the fires set by the government to defend against the wildfires and said that should be the focus of the court's attention, not the fact that there were a whole series of wildfires racing towards the point where the plaintiff's property was harmed. So what we see in the results here is that now all of a sudden it seems the courts are willing to assume that the government's action was the primary cause of the loss to the property, and that the government is forced to prove on the fire side this concept of necessity. So the other way I said, the other theme I saw was the type of analysis the court was doing. Before it looked at physical takings type analysis. Now it's looking more at a regulatory type analysis. The key things the court used to look at are things like the physical nature of the invasion, the permanence. Permanence is a big piece of physical takings. Is the damage forever? And was the property owner ousted, that is, prevented from complete use of their property? Those are the kinds of themes you see in a physical takings case that seem to all of a sudden be gone from the analysis in the most recent disaster cases. There's the permanent invasion concept. In the fire, you see this interference is permanent. So the whole permanence concept seems to have fallen out. And in fact, in the St. Bernard case, the court has said, the trial court has said, that the taking is now finished. That when the Mr. Go was closed, the taking ended. So the whole concept of permanence has kind of been turned on its head in this arena. The type of analysis now is more on a case-by-case. It's more like the Penn Central, right? And it co-opts certain themes that you see in the Penn Central test. The first is, what was the nature of the government action? And this really seems to be the focus where the courts are going now. What did the government do to either cause this in the first instance, and what did it fail to do to prevent it on the back end, right? So that seems to have become the court's zero-in focus point. Investment-backed expectations. Did the property owner have an expectation that their property would be protected from these harms? One of the important things, and Justin will talk, I think, a lot about this concept, is that can you really have an expectation that your property will not flood if you build homes in St. Bernard Parish and the lower Ninth Ward? Can you assume that your home will not burn when you build it on the edge of a national forest that routinely and by nature is going to have substantial forest fires, right? Or have you come to the harm, at which point it shouldn't be the government's responsibility to protect that property. It was your decision. The funny thing is that the third component of the Penn Central factor, the economic impact, seems to be completely lost in this analysis. What the court should be doing, if it's truly going to apply the Penn Central factor, is it should be saying, okay, what percentage of the harm was caused by the government, and what percentage was caused by the storm? If the government's contributing factor is very small, then under Penn Central, you would find there is no taking, that the cause is the storm. But the courts recently that have been moving more toward this multi-factor test seem to have left out this most important factor for the government's defense. And in fact, in St. Bernard Parish, you see the court unwilling to take on the issue of how much of the flooding was caused by Hurricane Katrina and how much was contributed by the fact that the Mr. Go was placed where it was and was operated in the way it was. I think all of the experts who testified in the case would have agreed that some flooding would have happened on all of those properties, regardless of whether the Mr. Go was ever built. And so the question really should have become, how much extra harm did the government cause? the final thing I want to talk about is this idea of necessity. This is really in the fire context, right? Before, the question was one of background principles. The first step in a takings case is the property owner has to come in and prove they have a property right, right? So let me take an example in the fire cases. There's a case called Bowditch. This is back in the late 1800s. Boston firefighters went in and they tore down somebody's house. House was not on fire. It was several houses away from houses that were on fire, but they had determined that it was the best place to put a break in the wood-constructed homes that were potentially in the line of this fire. And so they tore the house down. And the court came in and said basically to the property owner, you need to prove that you had a right to stop the government from tearing down your house. That is the way the court analyzed the taking there. The first requirement was on the homeowner to say, the government had no right to tear down my house, because the assumption at the time in the law was that the government had the right, under the police power, to abate a nuisance. Fire coming along is a nuisance. The government is basically taking an action to protect society at large, and it may have an expense for the individual property owner, but the government doesn't have to pay for that because it's operating under its police powers, right? So the burden was placed on the property owner in the first instance. Now, what you see is that the burden has been moved on to the United States. And so we're now in the now. The courts have shifted this to a common law defense that's called actual necessity. The burden's been placed on the government to prove, one, that there was imminent danger, two, that it was an actual emergency, and three, that it was necessary for the government to act, and I have added, and I think this is the way the courts have applied it, in the way it did. And so you can see the consequences here in these fire cases, right? The government now having to prove that in the onslaught of massive wildfires coming at them in the West, the decision makers now are going to be left in the position of saying, what do I do? Do I create a fire break on this private property, including potentially burning down the home of a homeowner, to protect millions of additional acres and other private property owners? Or do I let it burn because if I burn it down, I might be responsible to pay the homeowner? Is that the sort of decision we want decision makers in the government to be making when they're acting under their police power to abate nuisances on behalf of society at large? And I'll leave you with that question as an important one that I think we have to address. The one last thing that I would like to do is kind of go right to the end of my talk here and tell you that I think that something larger than the law is going on here. And this is just a conclusion that I have drawn. By the way, let me point out something that I forgot to mention at the beginning that I need to, and that is that while I am at the Department of Justice and I am part of the federal government, comments I made here today are mine and mine alone. Okay, they are not the Department of Justice's. The additional thing I see going on here, and what I think is the real culprit behind this movement, is actually the sentiment that Americans have with respect to our government. This shows from 1958 to 2013 the trust, basically, that people have in our federal government. In 1958, 73% of people who were asked said that they trusted the federal government to do what is right just about always, or at least most of the time. By 2013, that number had driven down to 19%, right? An interesting dichotomy of this is that here is a gentleman who is thanking Forest Service firefighters for protecting his home during one of the recent heavy fire seasons out west. If you narrow into his shirt, what you will see is that that thankful man thanking the federal government had a shirt on that said, lower taxes plus less government equals more freedom. So I will leave you with that thought and your feelings of the federal government as this conversation continues.
Good afternoon. I'd like to see that everyone's eyes are mostly still open, even as we enter the sleepy time of the afternoon. Thanks so much to all the students who are helping organize this terrific summit, and to Mark for leading us off. I am going to be sort of gearing my remarks a little bit more towards the fire context, because in Denver, although recently we have had some pretty significant floods, historically we've been more concerned about fires, and I, in general, will be talking also about cases that are brought against the federal government, although the same principles would apply in a context in which a state was a defendant. And the basic thesis that I'm going to propose is that, contrary to the way the courts are currently approaching these disaster-induced takings cases, a primary and perhaps dispositive element or doctrine should be to look at what the pre-existing natural baseline risk of a property was prior to the government's action in order to decide whether or not there's even a cognizable claim. And to sort of set that story up for you, let me provide a sort of an imaginary hypothetical in which we could probably dispute how close to the truth it is, but we'll put that to the side for the moment. Let's imagine we have a forest in the northern Rockies that burns on average once every 20 years. Let's imagine it burns every 20 years like clockwork. Let's also imagine that there's some chemical compound that can be sprayed on the forest that will delay that sort of incineration for 4 years. But at the end of those 4 years, the chemical itself will spark and ignite the fire. So you can sort of see where I'm going here. I'm a property owner. I live in this forest. It's year 19. I know a fire is coming down the road next year, but the federal government decides, perhaps because I have a powerful senator who funds this in an appropriations bill, to spray this chemical on the forest, giving me 4 additional years of use of my property in the absence of fire. But then in year 4, it is the chemical itself which ignites the fire. The question, I think, in a lot of these natural disaster takings is, do I, as the property owner, now have the ability to turn to the government and demand compensation? Because in some sense, we can think of the government's action as being the but-for cause of the taking, right? It's the chemical that the government distributed, which ignited, burned my property. But in another sense, the fire really is caused by natural conditions that long predated the government action. Now, one of the reasons I think this topic is particularly timely and relevant to the discussion of climate change that's been going on today, and I cited on the National Security and Climate Change presentation from this morning, where this issue is discussed, which is that we continue to heavily incentivize the construction of infrastructure, homes, and businesses in areas that are subject to significant disaster risks. Right, we do this through insurance, subsidized insurance. We do this through building code decisions. We do this through disaster insurance. And I'd like to suggest to you that recognizing robust takings liability ends up just becoming yet another subsidy for development in disaster-prone areas. Indeed, you can think of takings liability as just a substitute for insurance. Right? That's really what we're doing when we're allowing someone to recover damage to their property that was caused by a natural disaster from the federal government, is we are making the federal government or a state government an insurer of that person's property. Right? Just like you would turn to State Farm if your house burned down to recover the loss that you've suffered. Instead, you're turning to the federal government or state government via the takings clause. All right, so I think sort of one other piece of context here, and I think this is my fear, and it goes a little bit towards some of the comments that Jim's made. I think what's happening, and the reason that we're beginning to see this shift in natural disaster takings, is that there's a sense that the federal government or a state government has done something wrong, right? That in the context of the levee construction or some of the Corps' operations, that there was some fault at play. And as a result, as a matter of fairness, property owners should not have to bear that loss when the government has committed what in essence is a tort. But there's a long line of case law separating tort claims from takings claims, and notions of fault are not supposed to be a part of the architecture of regulatory takings, and for good reason. But I guess part of the reason I think courts are beginning to sort of blur these lines is because of concerns about the availability of tort law against the government, particularly under things like the Federal Tort Claims Act, which is sort of beyond the scope of the presentation. But there are sovereign immunity issues that sort of crop up if you're trying to bring tort claims that don't crop up if you're bringing takings claims. And as a result, there's sort of this instinctual sense on the part of judges that certain property owners should get something from the government. And if takings claims are the only way to sort of get there, they're willing to bend the law of takings in order to provide some relief. But I think we also shouldn't overlook that in many of these circumstances, there is going to be legislative relief available as well. Right? There are significant natural disaster assistance programs. I actually think many of them are misguided because they just perpetuate risk. But whatever I think of them, they are certainly available and they provide substantial relief. So the inability of a landowner to bring a takings claim doesn't necessarily mean there aren't other options. All right, so a little bit about fires and construction fire-prone locations. As with other areas subject to natural risks, these happen to be areas that are very appealing to people when it comes to living there. Right? I mean, if you think about the Rocky Mountains, people want to have their ski houses, they want to have their summer retreats, and as a result, people build a lot in areas that people often refer to as the wildland-urban interface. These are areas that are sort of interspersed forest lands and development. Indeed, there's an estimate that between the 25 years between 2006 and 2040, 35 years, Department of Agriculture estimates that there'll be a 50% increase in the number of houses in the wildland-urban interface in the Rocky Mountains. So we're talking about significant increases in property in development. You see the same thing in Florida in the context of hurricane-prone areas. St. Lucie County is a county that's expected, sort of the National Weather Service predicts that they will be hit by a major hurricane every 18 years or so, and yet if you look at the number of new houses being built in that area, it's just astronomical growth. And of course, alongside these increases in development comes increased in the expenditures that the government already spends on trying to avoid natural disasters. The Forest Service alone spends about almost $2 billion a year on dealing with forest fires, both on the mitigation side, but primarily in terms of response. So, to get into the way that these claims do occur right now, or perhaps the way that we could think of them, there's sort of two different kinds of parameters we could look at. One, we would look at the natural setting that resulted in a fire, sort of a baseline approach that I'm suggesting, or we can look at the governmental action or inaction and its justification. Right? We can sort of take a broad look at an ecosystem in assessing whether or not a takings claim should be available, or we can look very specifically at the incident itself. Now, this is just a map to give you a sense of historic fire frequency. So I'm not talking about baseline risks. There are baseline risks that are very severe in most natural ecosystems and sort of natural landscapes in the United States. I mean, if you can look at the numbers, right? I mean, we have areas where we have fire intervals historically that were on the scale of once every 2 years. Around here, in some of the wildlands, those intervals were sort of in the 6 to 8 year range. But there are very few parts of the country where natural fire risk, in the absence of any sort of development, was so infrequent that it wouldn't affect development decisions. So why do I have any justification for suggesting this natural setting and baseline risk might be relevant? Well, there is actually a little bit of precedence. It's actually the same case that Jim just talked about. He was expressing his concern that the Arkansas Game and Fish Commission case, the Supreme Court case from a few years ago, might sort of colonize the regulatory taking or the takings doctrine with respect to natural disasters. And I think I share some of his concern, although there is this one passage in the decision which gives me some hope. And at argument, indeed, the justices asked a lot of questions about whether or not the property at issue that was held by the state of Arkansas had been subject to flooding of the type that it was complaining of prior to the construction of the dam at issue. And the court notes its finding that such flooding had not occurred. Right? So that, in essence, one could suggest that the court is looking at baseline here and saying, well, this property actually wasn't subject to any baseline risk of a flood of this sort. There's no historical evidence that there were floods of this duration and this severity prior to the government's action. And so perhaps as a corollary to that, we could say, at least it should be relevant, the Supreme Court is suggesting, that if there was a risk of the precise disaster that a property experiences prior to any government action, that should figure into the takings analysis. All right, so I'm going to talk briefly about what types of government actions we might envision in the context of fires, many of which have been the subject of takings claims. You can sort of draw inferences, I think, to similar types of circumstances in the flooding context or the context of other disasters. First, sort of general management of forests, right? Or you could think about general government activities in watersheds that are going to affect flood risks through development practices and the like. But we have seen a case, 2009 Kerry case, where the plaintiff alleged that sort of general Forest Service management of a national forest had increased the risk of high-intensity fires. A high-intensity fire had occurred, and as a result, the Forest Service should be on the hook for damage. The Court of Federal Claims, which if you're not a Fed courts junkie, is the only court in the country that has jurisdiction over monetary claims against the United States, grants a motion to dismiss filed by the Department of Justice, and the Fed Circuit affirms. Right? So this is, I think, in Jim's typology, this would be sort of like an old model of cases rather than the new model of cases. And the Fed Circuit says, look, the fire wasn't the direct, natural, or probable result of the Forest Service decision, and also goes on to note that the government obtained no benefit for itself through the burning of this land. Right? I mean, the government didn't want this fire to occur. Indeed, the government had invested heavily in avoiding forest fires, and the fact that a forest fire had occurred nonetheless didn't mean that the plaintiff could seek compensation. All right, so sort of the second type of claim we can imagine, control burns to reduce fuel loads. This is sort of off the example that Jim gave of a control burn going out of control. There have been no takings cases in the Federal Circuit dealing with this circumstance, but there actually have been a series of tort cases, mostly in state court, but some against the federal court as well. And in one case, the Ninth Circuit held that the tort case could proceed despite what I would have thought would have been a sovereign immunity defense that would have been very strong. And I actually don't think the NRD didn't litigate the Green case either. That would have been a civil different division. So for whatever reason, ordinarily if the government is engaged in a discretionary function, there can be no tort liability. But here in Green, the Ninth Circuit allows a tort case to proceed in a circumstance where you have a controlled burn that gets out of control and then damages the property of the plaintiff. Right. So, third possibility, a response to wildfire doesn't protect property. Right. So you have a wildfire that's burning. The Forest Service and others are responding in the ways that they are able to, but their response fails to protect a property owner's parcel from the fire. That property owner could then turn around and say, government, you should have done more. You should have protected me. And we do have a case exactly along those lines. The plaintiff in the Teagarden case alleges that the Forest Service's prioritization in fighting the fire left him out of the cold, essentially. Right? The Forest Service decided to protect areas where there was more human habitation and higher value timber, and sort of deployed its firefighting resources accordingly. Teagarden property did not fall into one of those categories whose property was unprotected. Court of Claims grants a motion to dismiss. And again, it looks a little bit like a causation analysis, right? The court says the plaintiff can't escape the incontrovertible fact that it's the fire, not the Forest Service, that caused the destruction of their property. All right, in our final type of government action that I can envision, at least, there may be others, is what was at stake in the Trinco case that Jim mentioned. And this is a case in which, in response to a wildfire that that the Forest Service is trying to combat, they light what's called a backfire, basically to destroy fuel loads, create a fire break. That backfire is lit on a piece of private property, at least in part, and the plaintiff files a lawsuit, and the Court of Federal Claims in the Trinco Investments case grants a motion to dismiss, saying that as a matter of public necessity, the landowner lacked a property interest that was sufficient to substantiate a takings claim. But here the Fed Circuit reverses, right? And I'm not going to go into a lot of detail about this case because I think we already heard a bit about it, but the Fed Circuit reverses, essentially placing the burden on the government to prove that there was a public necessity, and we're not sure exactly what that means, but that there's some element of proof that the government has to put on. And at least one state Supreme Court has followed suit. In the Brewer versus State case, the Alaska Supreme Court relies heavily on Trinco to develop and apply the law in a case against the state. So, as I mentioned, the proposition that I want to suggest to you, and if any of you know any judges, you can suggest it to those judges, is that the focus here is wrong. And what we should be focusing on instead is whether or not people are constructing in wildlands that have historically been subjected to repeated wildfires. What was the natural baseline risk? Same thing in the context of flooding. Are you building in a flood zone? If you're building in an 100-year flood zone and your property floods, at least to my mind, that should prevent you from bringing a takings claim, irrespective of what actions the government might be up to. Now, again, that doesn't necessarily mean you can't bring a tort claim or something like that, but from a takings perspective, you should be precluded. Now, there are a couple of doctrinal bases, I think, for this. First just has to do with the reasonable expectation of property owners. Right? If you think back to your first-year property class and the Penn Central test for regulatory takings, which the courts in general and the Supreme Court in specific does seem to be importing into this other area of disaster-induced takings. The reasonable expectation of the property owner are a primary driver for analysis of a takings claim. And if you are constructing in an area that is subject to a baseline risk, I would suggest you have no reasonable expectation that that risk will not manifest at some time. There's sort of a second doctrine which has never been adequately explained by the Supreme Court, but there's this notion of reciprocity of advantage that runs through Supreme Court takings law. And some states have actually developed much more robust doctrines of reciprocity of advantage. And the idea is that if you as a landowner have benefited from the types of government actions that you're now complaining of, you shouldn't be able to secure compensation because you've now also suffered a loss. Right? And so you can imagine the way that this would play out. Thinking back to the initial hypothetical I suggested to you, if you were able to, have you been able to enjoy your property in better condition and for a longer period of time than you would have been able to in the absence of government action, then at the point that that disaster finally does visit your property, you shouldn't be able to seek compensation. And then finally, I think there's sort of a causation issue that one could ask, and that, as I've described, several of the wildfire cases do look a lot like causation cases. And one can ask whether or not it's really the government action that is the cause of the disaster that struck your property, or is the baseline risk that your property faced sort of the cause, because if the fire didn't happen this year, if the flood didn't happen this year, it surely would have happened sometime soon in the future. Finally, just I was sort of thinking through where else could you apply a baselines approach. I think there's sort of obvious implications for floods and hurricanes, maybe landslides. I think if we're thinking about things like earthquakes and tornadoes, it seems a little harder for me to figure out how you think about natural baselines, only because it seems a lot harder for me to think about how you sue the government in the first place, alleging that some government action facilitated a tornado or earthquake. Although potentially you could sue a local zoning board and say that the zoning board didn't adopt enough sort of stringent enough zoning to protect you from yourself. And with that, I will conclude, and we will hear, I think, another perspective on these issues.
Good afternoon. I'm Randy Smith, and I represent property owners and have been doing so for over 25 years. So I have a little bit of a different perspective, but I have a lot of respect for the last two speakers and agree actually with a lot of what they're saying. But where I intersect with this primarily is when people come to me and their land is being taken by the government or has been taken by the government, or there's proposals to take their land in one way or another, or their land or businesses have been affected by some governmental development. Now, as I said, I've been doing this for a long time, and a lot of these types of cases have nothing to do with natural disasters, road widenings, new hospitals, expansions of convention center, expansions of ports. And so there are a lot of taking issues that come up in terms of the necessity of the taking. I've represented some landowners whose land is still sitting vacant after being taken, and despite us fighting over the necessity of the taking and whether the project would ever happen, and my telling the judge, I bet you it's still going to be sitting there in 10 years. You can look by Chapatula Street and the river and see some of my client's property, unmowed grass that was taken back in 2000 for expanding the convention center that never happened. You can look at the corner of Claiborne and Canal that used to be a huge office building hotel that was taken for the new LSU hospital and is sitting vacant with no plans for development because the government has extraordinary power to come in and say, we think we're going to need this land, or we may need it in the future, and the courts don't stand up that often to the taking itself, and so you're left with just compensation. And we come back to the fact that, when this country was organized over 200 years ago, it was a very important fact to the colonists that their land not be taken without just compensation. Apparently, they'd had a lot of issues with that in the 18th century with the British just commandeering their homes and businesses whenever they felt like it and not being compensated. So in the very Bill of Rights, the first 10 amendments to the Constitution is included that nor shall private property be taken without just compensation. And that's been around a long time. Louisiana, similarly, as Mark was alluding to, in their Constitution has an even stronger statement that a landowner shall be compensated to the full extent of his loss. And there's a lot of litigation that we certainly don't have time to go into now about what differences there may be between those two terms. But the fact of the matter is, throughout this country and in other places in the world, although less so, I would say, from my experience internationally, than in the United States, is a true belief that one of your fundamental rights and part of your liberty is that you have a piece of property that it should not be taken, whether it's physically taken or taken by a regulation preventing you from use of it, or taken by servitudes without just compensation. So as that backdrop, let's focus on this. There is a disaster like the Katrina flooding or like the wildfires. And the last two speakers have been speaking of, and there's obviously a lot to be said about whether there's liability of the government for failure to properly protect against natural disasters. And I think that's been touched on, and I think everybody's familiar with the important rulings in Katrina here by the Fifth Circuit Court of Appeal that the federal government had sovereign immunity for the badly constructed levees, and yet the Court of Claims ruled that, well, Mr. Go was something the government did, and in a takings context, as opposed to a tort context, there might be some liability, although that's still being adjudicated. But I'd like to talk a little bit about, okay, what does the government do after the disaster to try to fix the problem? Here's an example of a case I had where you had a piece of property that was on the industrial canal that had a business, and they enjoyed the use of water, rail, and road for their business. Well, because of Katrina, the government said, sorry, we need to put a levee up here. And they took the front of their land and built a wall. A totally reasonable thing to do. We didn't contest that. The question is, who pays for the resulting damage to the property? Is it the landowner's contribution to society because they own land by water that needed to be protected, and they should just say thank you very much and suffer the fact that they now don't have water access to their property? And as we pointed out in this case, we tried to show the jury with slides like we show when we teach. You know, I do a lot of jury trials, and one of the things I like to tell jurors is, you know, this is a class you didn't sign up for. And I apologize. We'll try to make it interesting as much as we can, and one of the ways you do that, I think, is through your presentations. But, you know, most jurors I've found take their responsibilities very seriously nonetheless, even if they have absolutely no interest in property rights. But here, for example, just to show you a real case, this was the kind of presentation we made. So they took the front of the land, and this is the value before, and the appraisers argue about the value before. This is the value of the part taken. The government, in this case, had plunked down $175,000 for the value of the property taken. The appraiser that we had said no, was worth $683,000. That's typical in a takings case, arguing about value. But that's not really what was interesting here. What was interesting was that the government's position here was that, you know, yes, you're entitled to be compensated for the land we took on the water, but you still have the rest of your land. And there was an implied, if not express, appeal to the court and to the jurors, as there are in many of these cases. You really, you know, are overdoing it, landowner. We are trying to help society here by putting this up, and you want to make money from us because of it. On the other hand, the landowner's like, we pay our taxes like everybody else, but not everybody has their land and their business impacted. We have the rest of our land, yes, but we don't have water access. We calculated that without the water access, through appraisal testimony and other testimony, that the remaining land was damaged severely. The government's position was that the rest of the land, as I said, stayed. So to illustrate this in this particular case, just to show you how fun trials can be, I literally cut my tie off in the middle. That's why there's the half the tie there. At the end of my closing statement. And even the judge was holding back from laughing. The jurors were looking at me like I was crazy. And I said, I still have this part of my tie right here. Right? Is it worth the same? I don't have this. The jury came back and agreed they compromised on some of the numbers, but they found there were damages to the remainder. That's the kind of argument you'll have in any kind of takings case. But what is special about post-taking disaster cases? Well, in 2006, after Katrina, the Louisiana legislature, with a lot of lobbying from the levee districts, passed some legislation to try to limit their responsibility to pay for land or servitudes taken to construct levees. And I analogize it a lot to what happened after the 9/11 attacks in the Northeast, that Congress immediately rushed to pass an act to try to combat terrorism and created Homeland Security and created an awful lot of power of the government to invade people's private lives in the name of preventing terrorism. That act was not renewed some years later. Similarly, in a rush to deal with the Katrina disaster, amendments were passed and statutes were revised to try to put in place an argument for the levee districts that they might not have to pay when they took land to construct new levees or to improve levees. I've had a lot of cases regarding those laws since. In fact, I just argued this past week, in the First Circuit Court of Appeals in front of a 5-judge panel after a 3-judge panel hadn't decided, and I'm sure it'll go to the Louisiana Supreme Court, the first case addressing the meaning of those 2006 amendments. And it ties in with what we're talking about here and some of the comments that were just being made by Justin about if you live in a fire area. So the argument that the levee boards are making is that if you are in any type of riparian ownership, meaning on navigable waterways or the like, if you might be subjected to flooding, then you are subject to the government coming in and utilizing your land to protect your land and other people's land. And that goes back to a doctrine that essentially is that when land grants were originally given to people, if at the time that land was given, that land was riparian, that land was on a navigable waterway or was subject to flooding, that you knew at that time, kind of like what Justin's saying, that you should have known if you didn't know, and it carries with the land, that there's a right of the government to do what it needs to do to protect that land and other land around it. And so based on that concept, some of these laws have been written to say, we don't owe a thing if we come along and take your land. That last case I showed you was based on other statutes and wasn't brought into play. But what's been going on since, as I put on this slide, is a lot more use of not actual expropriations or takings, but commandeering orders or letters, thanks to these new statutes, more in the nature of appropriations than expropriations, where the landowners basically put on notice that his land's being taken. The case I just argued in the First Circuit is interesting in it's taking it to a further extreme. Representing a couple named the Jarrows down in Cutoff, Louisiana. And Mr. Jarrow had a dirt operation there. There's really good red clay that the levee boards really could use for building new levees. So they actually took an acre of his land for his dirt. They didn't use it to build a levee adjacent to his land or on his land. They actually took the dirt to use a mile or two away for a levee in the area, but that had nothing to do with his land. Yet they take the position that because it was for levee purposes, And because he's in cutoff Louisiana, all of which is basically subject to flooding and riparian land, that they don't have to pay a dime. And what they took from him definitely had value. There was uncontradicted testimony of how much dirt he was digging, how much was left, how much it was worth. And the trial court ruled in favor of the landowner. It said, here's an award for this dirt. To make matters worse, when Mr. Jarrow, not super educated, got his letter of taking, it was literally a letter that said your property is being taken for a servitude, and it attached a resolution, and didn't really mean anything to him, and he just kept on digging. So it was actually the levee district who sued him and asked for an injunction to stop him from digging his dirt, which they said was now on their property, and for damages for the dirt that he'd taken away from them. So that's when he got in touch with me somehow to defend him, and we explained to him that they had really, believe it or not, even though this is America, a lot of people don't realize the government can just come in and take your land like that. He had no clue, but he agreed by consent to stop digging there, and he agreed that he understood that they'd taken his land. But then we got into the fight over the value of land. Well, the levee district, to this day, and then took the position that they're entitled to damages from him for the value of the dirt that he deprived them of, and they actually got a judgment back against him in the case that I tried, because the judge was even-handed about it. The judge said, yes, Mr. Jarrow, you get the value of the dirt that the government has taken from you, but the government gets a credit for the $16,000 worth of dirt that you took from them after the taking. Well, they're not happy with that, so their position going up through the appellate courts, and I'm sure the Supreme Court, is that they should get money for the dirt he took from them, but he shouldn't get anything, because it's ultimately riparian land, and because of interpretations of these 2006 amendments, which gets complicated, but basically the levee boards got the legislature in the post-Katrina time period to put some things in that said, well, when it's levies, the full extent of the loss doesn't really mean the full extent of the loss. It means fair market value as defined by the U.S. Fifth Amendment. So I'm sitting there arguing to the Baton Rouge lawyers about United States Supreme Court cases and the meaning of the Fifth Amendment. And even though it's a case of first impression as to the amendments, it's certainly not a case of first impression as to the Fifth Amendment, because there are a lot of cases, and this goes into the bundle of rights that are property interests that the first speaker was telling you. Mineral rights, they're part of your rights. So there's some recent cases here, I'll put up here, where in St. Bernard and other places in this area, as well as in other places in the country, where the courts have said, yes, part of your property interest is not just your land, it's the improvements on your land, it's the things you grow on your land, it's the trees on your land, it's the minerals on your land, it's the dirt on your land, and you're entitled to be compensated for those things. Illustrate that your typical fee taking is just a question of, the surface, the length and width, whereas now you're getting into a lot more issues of what's below the surface as well. So in this Jarrow case I'm telling you about, this was what we were presenting was, what is the value of his land? It was only $11,000, but he had almost $200,000 worth of lost income from the value of the clay. And that's essentially what the judge awarded. But this little dirt farmer and his wife are now caught up in what's going to have a case of much larger importance, even though the amount of money involved is not that large, but it could be one of those cases that, as there are many over the history of jurisprudence, where it's Venice versus Michigan comes to mind, where it goes a long way, even though there's not a lot of value there. So the question is, what different bodies have to grapple with is who basically bears the burden of paying for the remedies for disasters, to come back to that. The legislature is going to have a say in that. The legislator, as I said, came in post-Katrina to try to change some of that calculus and make it not so burdensome on government to do things for the greater good. On the other hand, you have the judiciary, whose job is to protect the Constitution and the rights of individuals, not to have to subsidize everybody else just because their property is needed. And then finally, the jurors, who in many of these cases have to decide where they believe the right balance should be. This was a judge case here, which is another thing that the legislature has done, is in these cases eliminate the right to jury. So there's a lot of forces that go into play, and it's not just who's responsible for damages because of the disaster, but who's responsible for the remedies that we need to have after. Thank you.
We have time for a couple of questions, but there's one thing Randy brought up I think is really important for you to understand, and that is the nature of your rights and also the nature of the rights and obligations of government can vary based upon how property rights are determined. As he noted, in Louisiana, if you had a property next to a river, the state, when they gave you a deed, retained the right to build a levee. That's not necessarily a feature of deeds on canals, lakes, or the Gulf. So there may be different sets of rights and obligations. Also, the nature of expectations, when are those set? Because as we've seen, and this was really important in the St. Bernard case, is that everyone knows that you are subject to flooding in New Orleans. It can happen in the afternoon. But it was important to the court in St. Bernard that the Corps of Engineers, even though they had known that the Mississippi River Gulf Outlet was widening and becoming more of a risk driver, didn't tell people. They still described their system as a hurricane protection system, and that, according to the court, influenced the expectations that people had, which was, we may expect a flood, we may not expect a flood this way. Those are kind of important, but it gets to a question that I wanted to ask, and that is, if you're trying to protect against these kind of large cataclysmic events, climate change induced perhaps, but certainly it could be wildfire or storm, how imminent does that risk have to be before you can legitimately say this is a matter of necessity? Clearly we have climate change, and you look at the maps, Ed Richards talked about this morning. The projections for many coastal areas are pretty dismal. At what point do they become so dismal that governmental action as a matter of necessity can be brought to the table, which may be a defense against a taking claim? Where is that line drawn? Do we know? I'll ask each of the panelists for a short and completely accurate answer.
I would say that, historically, right, you're kind of in the realm of failure to act. When is the government responsible for failing to act in the takings area? And I think historically the courts would have said, never. The government's never responsible. And that has some pretty dire consequences. The converse of that has some pretty dire consequences. And that is, if we start to say that the government can be liable for a taking when it fails to act, how much will that impact their ability to move quickly arguably in other areas, it could be very favorable from a policy standpoint to put obligations on the government to act and to hold them liable for a takings. But I think that to my way of thinking, is more of a political question that should be addressed by the political branches than it should be addressed in takings jurisprudence.
I'm going to ask Randy that same question, but with one preface, and that is, in Louisiana, we already have at least one case pending, takings resulting from coastal erosion. And the argument is the disappearance of land, turning it into water, and shifting of mineral rights is itself a taking because the government has not prevented it from happening. Randy, same question. When does something become so imminent that governmental action or inaction is a matter of necessity?
I really agree that that's more of a political question, and there is more of a tort question to me than a takings question. I don't see that as a takings, a failure to act as a takings.
Ed, you had a question, I believe.
I do. Well, I'd love to argue science with you on Mr. Go. I've got a question to really follow up on yours. Let's say that a hypothetical city not unlike New Orleans next to the Gulf Coast gets flooded by another big hurricane, and the federal government says, okay, we're going to quit denying climate change. We understand it's time to go. We're not going to give you anything. We're not going to rebuild your levees. We're not going to provide any future protection, but we're going to buy you out. What's the measure of damages after the storm? Everything's destroyed, and without a government legislative bailout, there will be no rebuilding. Does the government have to pay prior value, or can the government actually pay market value? And I'm not, well, it's really very difficult to sort this out in the literature, so we've got 3 experts, and I'm really curious what they think.
So, I mean, my first answer would be that you're in the wrong arena to be in the just compensation phase. We need to be back in the liability phase. Why is the government responsible for, in the first instance, if that property had never been protected?
No, I'm sorry, not liability. This is just straight up and down. The government's trying to help people out, wants to get the folks out of the way so we don't have this come up before. They're going to buy them.
Right.
How do we value their property?
But there, I mean, like I said, that, to me, there's no taking there, there's no liability, so it can't be based on a just compensation basis, right? So it really, again, would be a political decision as to what the government is willing to pay.
They're going to turn into a farm. Yeah, they're going to have to take eminent domain, clear the houses out, plant some trees, and call it a day.
I think doctrinally the value is that that's sort of the black letter law. Now, whether or not courts are going to be willing to stick with that law because they're going to see a circumstance like what you're describing and say, well, now the day of the day, because the property's worth 25 cents an acre, we don't think that's fair.
What would
You might
you
see
argue?
pressure on
What would you argue with your clients that are getting the 25 cents an acre?
You do have some exceptions, and typically, as part of the scope of the project, rule, the government can take advantage of the fact that from the date of the taking, if you're taking some property right next to a brand new hospital that's being built with the takings for the hospital, even though that your value, your property is now increased because everybody wants to be right next to the hospital, the government's going to say, no, you don't get the benefit of that because that's part of the project that we're taking you for. You got to go back to before the project. You have to imagine it without the project. There's a corollary to that where you can argue that you should, because of the government delays or inactions, that you can jump back. More about time. There's an argument.
Okay. We're actually at our witching hour because we have another session
There's another
beginning.
session that has to start here, so sorry to
We
stop the
appreciate you
discussion.